Workplace bullying versus workplace harassment. At times, it is difficult to distinguish between workplace bullying and workplace harassment. Workplace bullying and workplace harassment involve similar behaviors. In the United States, the real distinction is a legal one. Workplace bullying is not illegal and does not violate federal anti-discrimination laws. Meanwhile, workplace harassment is illegal and does violate federal anti-discrimination laws. The Workplace Bullying Institute defines workplace bullying as repeated, health-harming mistreatment by one or more employees of an employee. Workplace bullying is abusive conduct that takes the form of verbal abuse or behaviors perceived as threatening, intimidating, or humiliating. Examples of workplace bullying are exclusion from professional activities, verbal attacks, isolation, spreading rumors, abusive criticism, humiliation, undermining your work. Workplace bullying is a global problem. In the United States, workplace bullying is legal provided it is not based on an employee's age, race, sex, religion, national origin, or disability. On the other hand, workplace harassment is illegal because it is based on an employee's age, race, sex, religion, national origin, or disability. Workplace harassment violates federal anti-discrimination laws. Workplace harassment is unwelcome conduct that is based on race, color, religion, sex including sexual orientation, gender identity, or pregnancy, national origin, older age beginning at age 40, disability, or genetic information including family medical history. Workplace harassment becomes unlawful where 1 enduring the offensive conduct becomes a condition of continued employment, or 2 the conduct is severe or pervasive enough to create a work environment that a reasonable person would consider intimidating, hostile, or abusive. Petty slights, annoyances, and isolated incidents, unless extremely serious, will not rise to the level of illegality. Offensive conduct may include, but is not limited to offensive jokes, slurs, epithets or name-calling, physical assaults or threats, intimidation, ridicule or mockery, insults or put-downs, offensive objects or pictures, and interference with work performance. To be unlawful, the conduct must create a work environment that would be intimidating, hostile, or offensive to reasonable people. Anti-discrimination laws also prohibit harassment against individuals in retaliation for filing a discrimination charge, testifying, or participating in any way in an investigation, proceeding, or lawsuit under these laws, or opposing employment practices that they reasonably believe discriminate against individuals, in violation of these laws. The harasser can be the victim's supervisor, a supervisor in another area, an agent of the employer, a co-worker, or a non-employee. The victim does not have to be the person harassed, but can be anyone affected by the offensive conduct. Unlawful harassment may occur without economic injury to or discharge of the victim. Workplace harassment violates Title VII of the Civil Rights Act of 1964, the Age Discrimination and Employment Act of 1967, and the Americans with Disabilities Act of 1990. The employer is automatically liable for harassment by a supervisor that results in a negative employment action such as termination, failure to promote or hire, and loss of wages. If the supervisor's harassment results in a hostile work environment, the employer can avoid liability only if it can prove that, 1, it reasonably tried to prevent and promptly correct the harassing behavior, and 2, the employee unreasonably failed to take advantage of any preventive or corrective opportunities provided by the employer. The employer will be liable for harassment by non-supervisory employees or non-employees over whom it has control, for example, independent contractors or customers on the premises, if it knew or should have known about the harassment and failed to take prompt and appropriate corrective action. The distinction between workplace bullying and workplace harassment is whether or not an employee is being targeted because of their age, race, sex, religion, national origin, or disability. Congress has not passed any federal anti-bullying laws. However, some states have passed anti-bullying laws. Workplace bullying can evolve into workplace harassment. An employee who is experiencing workplace harassment can file a discrimination complaint with the Equal Employment Opportunity Commission based on their age, race, sex, religion, national origin, or disability.